and welcome to this excellent panel. We have an amazing array of people to talk about reproductive rights today. I'm Emily Bazelon. I'm a senior editor at Slate and a law and media fellow at Yale Law School, and I'm really thrilled to be here with you. We're going to talk about this season for reproductive rights legislation and litigation, which I think it's fair to say has been a difficult season. I was writing about this issue a few weeks ago for the New York Times Magazine, and when I started my reporting, the numbers showed that somewhere in the range of 50 state abortion restrictions had passed since the Republicans took control of half of the state houses in the country last November. And by the end of the week, when I was finished my reporting, there were 64 new restrictions, and last week when I was looking at the new tally from Guttmacher, it looked like it was in the mid-70s. So this is a moment where, at least in the states, things are changing, and there's really this wave of incrementalist legislation happening. We're going to talk in detail about what's really going on the ground, but just to give you a couple of examples, a few states, including Arizona, have made it harder to get medical abortions in the first trimester by prohibiting doctors from teleconferencing with nurse practitioners who give out that medication and have been doing that without incidents for a number of years. And then another kind of au courant example are laws which either ban abortion from being covered by any health insurance program in a state or from the insurance offered by the new healthcare exchanges. And then there's another flavor of restriction which attempts to defund Planned Parenthood by taking away state funding for it. Those are just a few of the examples going on, and the panelists will discuss more with you in a minute. But I wanted to frame the discussion by talking about this trend toward incrementalist restrictions. The kinds of laws I was just talking about may or may not be clear violations of the standards set forth in Casey of how we can have abortion restrictions that are legal if they don't present an undue burden to a pregnant woman, and we'll talk more about that. But certainly the conservatives that have put forth these laws are pitching them as incrementalist. And so that's one new, or at least a new emphasis that I think progressives in the pro-choice movement are contending with. And another kind of frame for our discussion is this question about the constitutional values that are at play in this arena. You know, how can the pro-choice movement figure out how to talk about these high-order values like liberty and equality and dignity in a way that resonates when, to some degree, these battles are a fight over litigation, even though litigation isn't necessarily the best political tool that the movement may have available. And then I also wanted to ask a question about other social forces that are in play right now. A week, I think, or so ago, there was a very big poll about Americans' attitudes toward reproductive rights that came out. It had more than 3,000 adults polled. And the numbers of people who support abortion in all or most circumstances is pretty stable. I think it's 56%. At the same time, 52% of people think abortion is morally wrong. So you can see already some interesting interplay there. And then another thing that jumped out at me is that 70%, more than 70% of respondents said that the term pro-choice describes them well. And at the same time, about 2/3 of people say that they consider themselves pro-life. So perhaps these words have kind of lost their meaning to a lot of people. And then another fact that I couldn't help noticing was that they asked people whether they watched the MTV shows 16 and Pregnant and Teen Mom, which show very vividly what it's like to give birth as a teenager and take care of the baby. And it turns out that people who watch those shows are much more likely to support the right to abortion than other people. So perhaps MTV is the best, the movement's best stealth weapon in all of this. So here to talk about all of these issues are four amazingly qualified people. To my left is Linda Greenhouse, who, of course, for years was the Pulitzer Prize-winning Supreme Court correspondent for the New York Times, and is now a senior research scholar in law, Knight Distinguished Journalist in Residence, and a lecturer in law at Yale Law School. She is the author of the excellent book Becoming Harry Blackman, and also a book co-written with Reva Siegel called Before Roe versus Wade, Voices That Shaped the Abortion Debate Before the Supreme Court's Ruling. And then we have Jack Balkin, who is the Knight Professor of Constitutional Law and the First Amendment and Director of the Information Society Project at Yale Law School. And Jack is the author of many things, which I will not list, except to say that he has a new book coming out called Living Originalism. So you can look for that. And the practitioners among us to talk about what's happening on the ground are Louise Melling, who is the director of the Center for Liberty at the American Civil Liberties Union. The center is a newly created entity that encompasses the ACLU's work on reproductive freedom and women's rights and LGBT rights, freedom of religion and beliefs, and HIV and AIDS. And then, last but not least, is Helen Krasnoff, who is the senior staff attorney for public policy, litigation, and law at Planned Parenthood, which is very much, obviously, in the middle of all of these legal and political battles that we're having right now. And the last thing I'm supposed to say before we start is to ask you all to make sure that your cell phones are turned off in some way that they won't get in the way of the cup. And thank our sponsors. Yes, so actually there was a note to me to thank our sponsors if we had them. But of course, we don't have a sponsor for this panel, and that's not really a surprise, and I think it's part of the challenge of this issue. Whenever I find myself writing about abortion, I venture into tricky waters, and I think that is true for a lot of companies, that it's not the easiest stance to take and to identify with. And that leads right into the first question I wanted to ask this panel, which is, this panel is framed in terms of reframing and reclaiming the reproductive rights debate. And that, they're implicit in there is the assumption that that is, in fact, what needs to happen. And so I wanted to start with the question, is that the right assumption? And why is this moment where the pro-choice movement and its supporters should feel deeply concerned? And I think Linda will start us off.
Yeah, I mean, just to play off of what Emily just said, I gave a talk to a group of lawyers and judges in Philadelphia a couple weeks ago, and it was kind of playing off the book that Reva Siegel and I did, and a more recent article that kind of refutes the traditional backlash narrative that Roe started it all, and so on. And at the cocktail hour before my talk, one of the members of the audience said, "What are you going to talk about?" I said, "I'm going to talk about abortion." And I could hear the intake of breath. I said, "Well, you've got guts." Well, you know, why? Why does it take guts to talk about abortion? And I want to just note and welcome all the guys in the room, because it's not always the case that men express interest in this issue, although it's obviously an issue that ought to be of equal interest to all of us, and in fact to all communities that are interested in personal liberty and freedom of sexual expression and the narrative of our lives. And by that I mean not only the pro-choice movement, but the LGBT rights movement, and all of us who care about these issues. And I think building those kinds of coalitions is something that is very much worth talking about and thinking about. So in terms of Emily's question, the reclaiming and reframing, and is it necessary, in light of the fact that there have been, I think, close to 1,000 legislative proposals in the current legislative season that have turned the abortion issue into a convenient punching bag. And in light of the fact that even those office holders or public personalities who would regard themselves as pro-choice don't seem able to talk about abortion, if they can use the word at all, without a kind of a hand-wringing and an apologetic and tragic and rare and so on. Yes, I think there's a good deal of reclaiming and reframing that needs to be done. And it's not so much, I think, an issue of litigation strategy, although it certainly is that. And I think we have to be clear about where the Supreme Court has been coming from, and clear that Planned Parenthood against Casey in permitting only those kind of informed consent provisions and so on that are truthful and non-misleading, and a lot of what's going on out there, such as the South Dakota statute that requires women to go get, quote, counseling from these crisis pregnancy centers, which are not legitimate anything, and are not going to give truthful and non-misleading advice. We can talk about litigation, but really I think what the pro-choice community has to get its hands around is the cultural narrative about abortion and how abortion fits into the story of freedom in the United States. The poll that Emily mentioned shows us something really strange. I mean, there's a solid, not shrinking majority of the population that believes that abortion ought to be available in all or almost all cases. And contrary to a kind of a stereotype, those numbers are true across all age groups. So there's not, I mean, one typically hears that young women are less supportive of abortion rights than their mothers. That doesn't seem to be true, but there is a disparity. The poll also asked about opinion on same-sex marriage, and there was a great divergence where the millennials, the younger generation, was much more supportive of same-sex marriage than their parents. And so, that's obviously a set of statistics that needs some further exploration, or, as I said earlier, coalition building. But so on the one hand, we have solid, not shrinking support. On the other hand, we have legislatures and voters, evidently, who don't much care when these incremental burdens are put on access to abortion. And so what is going on there? I think the real thrust and impact of these, quote, incremental burdens are to marginalize abortion and give out the message that abortion is an anomalous incident in healthcare, and that women who seek and obtain abortions are somehow anomalous among all motherhood-loving women. I mean, there's a powerful family narrative that has enabled the LGBT movement to become so successful, I think, by embracing same-sex marriage. And somehow abortion is made not to fit into that narrative. It's just kind of sitting out there. And that's counter to the facts, and the facts don't seem to be available to most people. I mean, the fact that between 1/3 and 40% of all American women will have an abortion in their lifetime, that's not marginal. That's an inherent part of the narrative of women's lives. The fact that 40% of all abortions are unintended in this country, and that half of those will end in abortion, that's just a fact. That's not marginal. So I think the reclaiming and the reframing has to engage with the facts of women's lives, as well as very much the equality component and the liberty and dignity component that Emily mentioned at the beginning as part of, not at the margins, not at the anomaly, but just a core aspect of the way we understand lives in America today, in all of their crises and all of their diversity and all of the ways in which we think about families and family structure, and the fact that timing of pregnancies or the desirability of pregnancies are much of a family issue, as some of the other questions that we're involved with today.
And just add a little bit. I've been in the reproductive rights movement since 1989, and there's been a lot of bad days in the movement, but I just want to say I think this year is really striking in a number of ways. I think, first of all, in terms of how bad it is in the states, I think Helene's going to elaborate more in that sense, how bad it is at the federal level. I mean, there are measures that are passing, and they're also particularly audacious in the sense of the chutzpah that's behind a lot of these measures. But I guess what I want to reinforce what Linda said, which is, at this moment, I don't think any politician is really paying a price for stigmatizing abortion. that right now in the legislatures, things are just passing. When I asked people the other day, well, why didn't it pass in those states? And they said, oh, the legislature ran out of time. It wasn't because there was a real outcry. It wasn't because the politicians were made to be scared. And I think some of that has to do with it's a particularly venal moment in American, sort of state politics in some sense, right? Abortion's getting smashed, and so are a lot of other people getting sort of hit with us, including unions. But I do think that the stigma is the biggest issue, right? There's a real difference from when I came in terms of who's willing to stand up and say the word abortion, right? And this is just one small example. President Obama's statement on the anniversary of Roe omitted the word abortion. Kind of whacked, in my humble opinion. And I also think this issue, even in the pro-choice movement, we have discussions about who on a plane says what you do, who says, I defend the constitutional right to abortion, right? Who says the word abortion even among us to people when we meet them at a cocktail party? Who tells people that she or he was actually involved in an abortion decision so that women who've had abortions are no longer stigmatized in the way that LGBT people are no longer stigmatized? I just feel like it's absolutely imperative that people stop buying into this silence, and also that in this audience, that it is no longer quite as cool to sort of bash abortion as something that is embedded, the right as embedded in the Constitution. That we have to turn around these conversations at the personal level, we have to turn them around at the political level, and we have to turn them around in the legal at the legal arena. Otherwise, I can't really see how we're going to turn this around. And every single one of you can take a part in that, right? You're in this room because you care, but you have to start the conversation because there's just too much silence, and the silence is frankly just killing us.
Helene, do you want me to try and, I'm going to try and bring us back a little bit from the theory and just give a sort of overview for those of you who don't follow this every day like a lot of us up here do.
Here's what is happening.
In terms of drinking a lot and early.
In terms of what legislature has passed what and whatnot. And I'm going to go through some of the highlights of the trends we've seen this year and how many states and just some of the background information. And with that, then I'm going to try, hopefully, or you all can also try at the same time, to think about the things that we've said about abortion not being a standard medical procedure, about women who have abortion somehow being different, and how these laws feed into this dialogue. They all feed into it. So one that Emily mentioned is the insurance restrictions for abortion. Everyone probably does know that last year, as part of the healthcare reform debate, abortion was a very contentious issue at the end of the legislation, and we came up with a sort of compromise that allows abortion to be covered, but through purchase paid for separately to make sure that no federal funding goes to abortion, because another narrative that has encroached on the left is that no federal funds should go to any sort of abortion, and that's another sort of narrative about who are women in need of, low-income women in need of abortions, and why it's an okay place to start, which is where our president started as well. The baseline is we all agree no federal funds should go for abortion. So that's, set that aside. But an invitation, in addition to this sort of compromise to allow for abortion coverage, states are allowed to enact their own restriction in their own exchange that says, but not in our state. You can't have abortion coverage in your health insurance in our state. And last year, in the little period that was left of the legislatures, 5 states took up that invitation. This year, 23 more states introduced that legislation, and 8 of them have already, 8 were enacted, and an additional 1 was vetoed. So we've already seen in 1 year, these exchanges aren't up and running till 2014, but a good portion of the country, despite our hard-fought compromise, has already said not in our state. Insurance can include abortion. The 20-week bans, as they're called in the media, last year Nebraska enacted this law, and it's gotten a lot of media attention, a law that claims, based on purported science, that a fetus can feel pain at 20 weeks post-fertilization, that therefore abortion needs to be banned at that period. Now, as most of you probably know from Roe and Casey, that the line for banning abortion has always been viability. These 20-week bans, people really like the Nebraska ban, and 14 more states have introduced them this year. 5 of them are already enacted. Another big trend this year has been real increase in what we call TRAP bills, or targeted regulation of abortion providers, regulating abortion differently from other medical procedures. Some of this came from the Krasnoff situation in Philadelphia. I think really fueled and perhaps on some level rightly so, although there were regulations that were not being enforced. So that's the bigger issue for Dr. Krasnoff, but that's really fueled that. And so 19 states have introduced measures this year. 7 states have already tightened up their regulations on abortion providers. One also, which Emily alluded to, is we've seen for this year, for reasons that are a little unbeknownst to me, a little bit of an attack on medication abortion, which is, commonly known as RU486, or its brand name in this country is Mifeprex. And it's abortion by medication only that's available through 9 weeks. And Iowa's Planned Parenthood has got some press for having a pilot program to do abortions by telemedicine. And so a number of states have jumped in on that. Somehow people also learned that the standard protocol for medication abortion is not the one that the FDA considered when it was approved in 2000. And so they have decided to turn the clock back on science by 15 years to ban women from having what doctors think is the best regimen for medication abortion and make it less available. Two more areas to sort of anyway, 7 states have changed the FDA protocol issue. 3 others, I think, have done telemedicine bans, and two of the protocol changes have been enacted this year. The other legislation is these sort of what I'll just glump together as they go to the theme of the sort of protection of women from making their choices. And one that's been very popular is ultrasound legislation, which mandates that women not only have an ultrasound, but have to hear the heartbeat or hear a description of the medical images, even perhaps against their wishes, not just offer them to do that, under this notion that if women really knew what they were doing, they would change their mind. And then Emily alluded to this as well. South Dakota has kind of we'll lump it in this because it has nothing to be lumped in with in the world. South Dakota this year has taken what some states have a 24-hour waiting period. South Dakota has enacted a 72-hour waiting period where you have to meet in person with the same doctor who's going to do your abortion 72 hours in advance of your abortion. And not only do you have to do that, you have to have a very lengthy screening for coercion and for what's called risk assessment of any risk that may have been published in any journal article for the past 60, 80, 100 years and is available on PubMed. And then not only do you have to do that, you also have to go to a pregnancy help center, which is an organization that by definition must not perform or refer for abortions. So these are what we generally call crisis pregnancy centers. So you're in South Dakota.
Don't move there.
So Planned Parenthood of Minnesota, North Dakota, South Dakota is the only abortion provider. There's only one provider in South Dakota. Abortions are available in Sioux Falls approximately 1 day a week, and the only way that is achieved is by flying a physician in from out of state. There is no abortion provider in all of South Dakota. There's no doctor willing to perform abortions. So what this law means is in South Dakota, 30% of our patients come from more than 150 miles, and 15% come from more than 300 miles to get the abortion. So Rapid City, the other side of the state, is over 350 miles from Sioux Falls. So women are already driving 700 miles to get an abortion. But now you don't just have to do that. You have to wait 3 more days after you do that. You have to drive back again. It's 1,500 miles, as I like to say. You have to drive halfway across the country in order to get an abortion. Gas, as you all know, is $4 a gallon. Our patients are, like half of them live below 200% of the poverty level. And in addition, in that time window, in addition to having to do that, you also have to go to a crisis pregnancy center, and they get to do a screening to make sure you're not being coerced to have your abortion. And if they think they are, they can send a report over to Planned Parenthood to say, wait, we think they're being coerced. And Planned Parenthood can still go ahead, but remember, if you do an abortion when a woman's being coerced, you're subject to lawsuits. So that's the new South Dakota law. I mean, you'll, I assume, not be surprised to know that we've challenged that in federal court. It takes effect July 1st. There's a hearing on June 27th on our request for preliminary injunctive relief. But I think that law really kind of puts a lot together in terms of how marginalized it is, how hard it is for these women to begin with. And this would probably come later, but I'm on a roll, so I'll just I'll just say it, is that when you think about the legal standard and what's an undue burden, and in some of these waiting period cases, some courts, not the U.S. Supreme Court, but some courts interpreting Casey, have said you have to be prevented from having an abortion. And what's so lost here is this is not a decision like, should I wear this black dress or this beige dress today? Oh, you're going to make it harder, I'll wear the black one. It's women, poor women, most of them, who don't want to have a child. And so, yes, they will drive 700 miles. And why do they drive 700 miles? Because they need to, exactly. There's no, if the standard is you have to prevent women, if that's the legal standard, that you have to prevent women from having an abortion with a law for it to be unconstitutional, then there certainly is something legally that we need to reclaim. The very last thing, I promise, is about this defunding of Planned Parenthood, since I'm the Planned Parenthood representative, unless we want to save it later, because it's a little bit of a different character. But as you probably know, the House of Representatives, was known as the Pence Amendment, voted to defund Planned Parenthood from receiving any federal funds as part of the budget negotiations. The good news here, I think there's good news in this legislation, I really do, on some level, but the Senate went high water mark, 58 senators voted against defunding Planned Parenthood. Every single one of the Democratic caucus voted against it, even though all of them are not reliably pro-choice votes. But that wasn't enough to end it. 11 states are in the process of talking about this. It's still going on in lots of legislatures. 4 have already done so. 1 is in litigation. 3 others take effect July 1st, and people are considering litigation on those as well. But I think one thing, if there's any sort of good news about this, in addition to like the Senate thing, is that maybe this is where they've kind of overplayed their hand a little bit. In that I do think that this is where I think there may be a price to pay, to Louise's question a little bit.
Except the only thing I think about that is I think in healthcare reform, one of the things we saw, which I understand healthcare reform was about abortion, right? Was to the extent people, when we all do focus groups or polls or you talk to people, people don't like the intensity factor, I'll call it the hostility, the whatever that they perceive around the abortion debate. So I don't think it was helpful to us for abortion to become the thing that could make healthcare rise or fall. It sort of put it up there as, oh my God, that issue's so contentious, I really will go into a cave every single time I hear that word. And with the Planned Parenthood fights, I'm wondering how this will play out. So in Indiana, and you'll get the facts much better than I, where the Obama administration has come in to say you can't cut off Planned Parenthood consistent with Medicaid. And so the stakes are really high now politically. It feels to me like a game of chicken watching this. Is the governor going to risk Medicaid, and is the Obama administration willing to risk cutting out health care for poor people? So in the way of making this issue so polarized, that's the only way where I'm not 100% confident that it's overreach. It is overreach, and that, as somebody said to me the other day, Planned Parenthood is a good brand name, right? People believe in this, and people now see the square assault on contraception related to abortion, and so the two things aren't as separated as people have wanted to pretend they are. I think that's where it's really been. I do think that's the point I was going to make, is that I feel that this whole, a lot of you probably follow the John Kyle, 90% of what if you go to Planned Parenthood for an abortion, 90% of what Planned Parenthood does, and if not, you should Google John Kyle and Stephen Colbert or Jon Stewart.
And later said that was not intended to be a factual statement.
Correct. Well, you can look at the hashtag on Twitter. Yes, not intended to be a factual statement. And so I do think that the not just obviously, personally, what people knowing, what Planned Parenthood does and what Planned Parenthood stands for in general, is that I do think that the overplay of the hand is in suggesting that people are similarly opposed to women's health care in general and contraception, and that should be marginalized in the same way. And so I do think there's a tiny bit of tide to turn there, to use that to our advantage, and that maybe there's a price to pay a little bit to some politicians there, because the polling and the numbers and all of that are so good.
I was trying to think of a way to summarize a lot of these themes that are going around. It's very hard to do. I thought, here's one way into it. You may remember that Bill Clinton, when he was trying to become president in '92, said that his position on abortion was that it should be safe, legal, and rare. And that at the time was thought to be a way of creating a third way on abortion, a sort of compromise people could live with. And Neil Devins, about a decade later, wrote an article, and I generally speaking think very well of Neil's work, but he argued that in fact Casey, which is decided just around the time of Clinton's election, had solved the abortion wars. It had solved the abortion wars, he said, because
Let's go on.
it had solved the abortion wars, he said, because the compromise that had been reached was that abortion would be legal, but that states would be allowed to have incremental regulations and regulations that would be designed to dissuade women, but that states would not dare to pass laws that would strike at the heart of the abortion right itself. So this was, and I think he wrote this about 2004, 2006, something like that. And I think that for many liberals, this was a happy story that they wanted to believe in. It turned out not to be the truth. It turned out to be a very different story. And part of the way of understanding it, I want to go back to three basic ideas and see if I can explain how this happy story dissolved. One has to do with the Constitution, and the second has to do with, for better or worse, I'll just call it the closet, right, which is the points that you've been making. And then the third has to do with the idea of choice. Constitution. It was thought to be perfectly permissible to be a liberal in good standing during this period in Clinton years to go around saying how much you respected women's rights and contraception. But you know that row is really rather fishy. It's not really in the Constitution. It has no basis in the Constitution. And we understand why our very good friends are so upset about it because, we just... And so you would wave your hands. And this was a problem because, of course, what it did, it ceded a very important feature of American politics and American constitutional politics, which is if you have a right and you believe that right's important and you believe that right's in the Constitution, you should be willing to say that the right is in the Constitution and that you should be able to identify that aspect of the Constitution and where it says. Well, it actually turns out the right to abortion is in the Constitution. It follows from the Equal Protection Clause, and it follows from the Privileges and Immunities Clause. And if anybody asks you, where is the abortion right in the Constitution, I think you should say to them, what part of equal protection of the laws don't you understand? Equality, sex equality for women requires the right to choose the number and the timing of the choice of children. That's a right that's necessary not only for rich women, but also for poor women, not only for women who are single, but also women who are married, not only women who have children, but women who don't have children. This is a right that all women have. It's a right of the equal protection of the laws. It's also a privilege or immunity of citizens of the United States. Why? Because it's the right that women now regard themselves as always having had, or rather, always had a right to have. This is a point that's made in Casey, in fact, that generations of women have come of age believing that abortion was available if they needed it. Even women like Sarah Palin, who are completely opposed to abortion, expect to be praised for their choice to have a child with a birth defect. But you can only be praised, you see, if you think that you had the choice to have an abortion. So this is now privilege or immunity of citizens. Everyone should be willing to say it. This is now part of equal protection of the law. Everyone should be willing to say it. And this was a problem from the standpoint of this sort of third way compromise. The second problem was the problem of the closet. I have no better expression. We must come up with a better expression. But it really is your point and your point. That if you think about how was oppression of gays enforced, it was enforced by the idea that one didn't want to know about the existence of gays. And if one was forced to acknowledge the existence of gays, well, they were disgusting. They were abnormal. They were immoral. Right? That's the point. This is what has happened to abortion in the period in the last 20 years. That what has happened is you've seen this very interesting flip. Homosexuality has come out of the closet. Abortion has gone into the closet. Mm-hmm. And I don't want to use the word closet because the word closet has all sorts of theorizing about it that aren't appropriate to the abortion context. But the idea that abortion has been treated as it should be rare. That was Clinton's idea. That is, well, there aren't that many abortions, and you don't know anybody who ever had an abortion, and if you had an abortion, you really should be ashamed of it. This actually is the discourse that was used for the form of oppression of homosexuality. So when you think about, and it's been largely accepted, you see, it was accepted in the formula safe, legal, and rare. And so that was, in some sense, an unintended consequence of this sort of third way mentality. And we'll have to do more thinking about it, because I mean, I think that it's an easy an easy comparison to the closet. But I mean, we have to think more about what's actually going on. The third is the idea of choice. The movement for abortion rights is called the pro-choice movement. Part of it was a failure to understand that for every mobilization, the counter-mobilization will attempt to appropriate and reappropriate and turn upside down the basic claims and ideas and values of the mobilization that they're opposing. And so an important thing to understand about the way in which pro-life organizers reappropriated and attacked abortion under this third way idea was to argue that abortion was not a choice. Abortion was a coercion. Abortion was a refusal to offer women freedom. Abortion, and so this is David Reardon's famous strategy, and what he did is he went around trying to convince people that if a woman has an abortion, it's because she's been coerced. If a woman has an abortion, that's because she doesn't understand what's going on. If a woman has an abortion, it's because she's been subjected to something that's unsafe. To which Reardon was basically saying, you want something that's safe, legal, and rare? I'll give you safe. I'll add all of these regulations. Do you want something that's rare? I'll give you rare. I will increase the number of obstacles in the way, so it will be safe and rare. But moreover, do you want choice? Well, I'll give you choice, and this is the South Dakota legislation. The South Dakota legislation is 24 hours not enough. Take some more time, really. Take some more time. You really should have a choice. You want a choice? Well, you know, medicine is always changing. There are all these articles. The doctors don't know all the articles. There are articles that doctors don't know about. They prove that abortion is bad for you. They prove that abortion will cause health problems for you later on. They prove that you don't quite know what you're doing when you make the choice to have an abortion. The doctor needs to tell you about all that information, not all the other information that might persuade you to have an abortion. So you want choice, I'll give you choice. And then, you know, this is also an attempt to try to go after the doctor. Because if the doctor doesn't give you the right article, the article that says the right thing, then you'll go after the doctor. The doctor will be liable. And that's, in some sense, the greatest threat that we're now facing in the context of abortion. It's, to use the word incremental to describe this is probably a mistake. Mm-hmm. Why? Because this strikes at the very heart of the abortion right. It strikes at the heart of the notion that what the abortion right is about equal status for women on the one hand and autonomy for women on the other hand. By reinterpreting the meaning of choice here, you are undermining the concept of autonomy because you're assuming your baseline idea is women are misinformed, women are coerced, women don't have scientific facts in front of them. This is the presumption of any woman who attempts to have an abortion. That is, it's reinterpreting what it means for her to have a choice, thus that she has no choice at all. But secondly, and even more deviously, this model that's coming out in South Dakota and other places is subtly and insidiously changing the very idea of equality between the sexes. Why? Because behind Reardon's ideology and the South Dakota ordinance and other ordinances is the idea that the way you know that someone's choice is not a real choice is against a baseline of what a normal person in their situation would have chosen. And the implicit baseline here is that a normal woman would of course always want to have a child whenever she became pregnant. A woman who was actually a woman, right, and not a person who had been crippled by the kind of society in which we live, right, that real woman, her equality would be realized by her ability to choose to have the child. And so there's this insidiousness in this form of, quote, incrementalism, unquote, which is denying both bases of the abortion right. It denies liberty on the one hand, and on the other, in a much more troubling way, denies the idea of equality on the other.
That's a really useful theoretical and also historical summary and a lot to think about. I wonder, before we take questions, if we can talk a little bit about what the movement does next, what kind of strategies are effective in the face of these kinds of assaults. And I'm curious, I think, Jack, what you ended on, which for me is framed most powerfully by South Dakota's law, is in some ways the clearest thing for the movement to fight back against. You know, as Helene said, this will clearly be litigated. I think the notion that that is a paternalistic approach to gender equality. It's clear enough that when I was reporting out on this a few weeks ago, and I was talking to Charmaine Yost, who runs an organization called Americans United for Life, which is behind and really pushing for some of the other trap laws and the medical teleconferencing laws. She was quick to distance herself from the South Dakota approach. That was seen as more of an assault on Roe versus Wade, more obviously flying in the face of the standard of Casey, and I think also not in line with the politics of her organization. And so it was interesting for me to see that kind of crack. And so that's part of what you all need to figure out how to address, and yet there's also so much more going on, which may be trickier. I don't know who would like to start. Perhaps Linda, you might want to jump in.
Well, I think some more fact-based conversation would be a good way to start, because Americans United for Life is a really smart organization. They're the gold standard of the anti-abortion movement, and they have been for decades. And so when they oppose the South Dakota law and go for the ultrasound, they're very much behind the ultrasound and some of these others, I think be useful to just call these things out on them. I mean, discuss them. Let people know that the effort is to depict women as lacking the ability to know their own mind. I have here, so Texas has one of the toughest ultrasound laws. They've just passed it. And the Center for Reproductive Rights has an ad campaign against it. Trust Texas women. We need you to be part of this fight. Do you trust Texas women? I do, says Nancy Northrup, head of Center for Reproductive Rights, but Texas Governor Rick Perry and his buddies in the legislature clearly do not. So, really what's at stake here isn't, do you have to get an ultrasound in order to have an abortion? In many medical practices, the answer would probably be yes, even if you weren't required, or
although forcing you to look at the images and
look
listening to a description.
Or, is insurance available for abortion? Well, early abortions don't necessarily, cost that much. I mean, it's not about the insurance. It's about the stigma. It's about the marginalizing, and it's about the role of women, women's agency, women's ability to make life decisions for themselves. And I think it's, it would be perhaps useful to try to frame it in that way, because that's what's at stake. I mean, that's the real dimensions of the issue.
Do any of you want to jump in? Happy? Louise, go ahead.
No, I just want to say that what Jack said, that particular formulation about how to rethink the incremental regulations, what we've called incremental for a long time, was incredibly helpful, just in terms of, and urge you all to think about it in terms of understanding how to see these things that look like chips as opposed to central are in fact central to what we really think about. Because I think that is one of the greatest challenges for us, is to sort of find a way to communicate that to people and to make people sort of care about what sounds to them like a pain in the butt, but not really sort of the end of the world in a serious way. And I think we spend a lot of time at the ACLU trying to figure out, I sort of think like, oh God, I hope it's not in fact a seesaw, that LGBT goes up and reproductive rights has to go down. How do we sort of, watch where that's going to figure out, and how to capture some of the strategies that are successful. And I agree, we can't just sort of do exactly the same. That's sort of naive. But one of the things they've really focused on is not only finding a way to talk about their cases in a way that makes sense as a narrative to people's lives, not a legal principle, but a narrative of people's lives. Like, why would this matter to you? How does this touch you in a real way by telling stories, I think. But it is also to focus every bit as much on the culture, to really be trying to infiltrate, whether it's through TV or whether it's through, they literally have campaigns coming out of the ACLU in states called persuasion campaigns, and there's 2 different kinds. Tell 3 people. That's if you're LGBT, tell 3 people, you know, how hard it is. And, you know, people joke like, oh, Helen, can we get together for lunch so I can tell you how hard it is? But that it's important that people understand, and that's the way to sort of change people. And then they also, interestingly, have a campaign which is for straight women to tell their guys why they should care about LGBT issues, because they have research showing that's incredibly effective, which is all a way of saying that persuasion begins with people close to you, and that can't be overlooked, and that there's have to be multi-tiered strategies about bring along your friends and those people close to you, bring along the public by having a compelling story as opposed to, you know, sort of in our world, filed a lawsuit. That's not enough to move people. And then finding a way to have your legal story also makes sense, that so that the judge who, you know, is perhaps chicken, wants to go with you, is going to care enough about what you say.
So can I know Emily's the moderator, but I'm going to ask a question back as a result of what you've both said, which is on that last strategy, because this is the ACS, and this is about the legal or constitutional strategy. And I should be the one answering this as the practitioner, but I'm going to throw it back, which is, you know, so you talked about privileges, immunities, and you talked about sex discrimination, and so you're going into, you know, federal district court, and what is the right that you are what is the right that you have to get an injunction, because real women are going to stop being able to have abortions next week, or 2 weeks, or 13 days. And so what is the right that you argue to the court, and how do you frame that right, and what do we do about that? I mean, you obviously know I'm being a little snide, but
It's right at all. So, you know, Reva Siegel, sitting right here, wrote a wonderful article in Yale about the Gonzalez case, Carhart 2. And some of the stuff I was saying actually comes from conversations that she and I have had over the years. And Reva said that Reva's article makes a point that we've been handed a important litigation tool. What's litigation tool? It's under the Due Process Clause. It's not under equal protection. It's under the Due Process Clause. It's not under equal protection or privileges or immunities. These are, I said those things because I want people to understand the liberty and equality elements of what's going on. But of course, we argue these things under the Due Process Clause. But the idea was the idea that, you know, Justice Kennedy, for example, I know we're always talking about Justice Kennedy, but Justice Kennedy, for example, has made a big deal about the idea of dignity. Dignity is the watchword today. I understand that the California prisons are to be reformed because of Justice Kennedy's views on dignity. I understand that Lawrence versus Texas is decided because of Justice Kennedy's views on dignity. So apparently dignity is the watchword for us all. Now the question is, so we argue due process, and so we talk about dignity. And the question is, how can we use the concept of dignity both to invoke both the equality idea and the liberty idea? I mean, that's really that's the problem for the litigator. And I guess, and here, you know, I mean, I recommend Reva's article to you as a way of thinking about it, because she goes into it in much more detail than I will be able to. Think about dignity through the lens of equality. Dignity from the lens of equality is that if I stereotype you, if I treat you differently based on a set of stereotypes about what it means to be a woman, I am undermining your dignity. I am, all right, this is a vision of dignity. So you can bring the equality values into the litigation even though you don't get to cite the Equal Protection Clause because of Godoldig and Feeney, right, as you know. But you can still make equality arguments, you just make them through the lens of dignity, right? So secondly, how do you use dignity in the lens of liberty, which is the privileges or immunities idea? I guess what you have to there say is, what does it mean to give women informed choice? Casey is premised on the idea that what you're not allowed to do is browbeat a woman, you're not allowed to lie to her, right? But there are many ways. But there are many ways that you can treat a person very badly without ever overtly lying to them, and without ever browbeating them. One way you can do that is be paternalizing, treat them like a child. Right? And so one way of using that lens of dignity is to say that the South Carolina, I'm just using South Carolina as an example, is essentially treating women very much like children. And then you can bring in the equality of ideas. How are women treated in other kinds of operations in which they have to have informed consent? And so I guess that would be my first cut as what you would think from the standpoint of litigation.
You know, just in terms of the public.
And does that get you? That gets you somewhere, perhaps, in telling the narrative, right? I agree with that. It gets you
Which matters.
Which matters. It absolutely matters. It gets you far in telling the narrative, and I think maybe in that sense, I do think. I mean, someone keeps quoting me within our department saying, if at one point I just said something like, if we're not going to challenge this, we should all just go home on this sort of notion, like this sort of, and it was actually about equal protection. It was this is the law that sort of says this. Like, why are we here if we are not going to be, if you force women to do this, and we're not going to stand up to that, which of course we are. But, so I understand the narrative. I think something that I don't truly see how the narrative fits into the legal test that a court is like sort of left with applying on some level.
But even if you did equal protection just based on treating women as dumber than men when it comes to decisions, right? Because that's part of what this is, right? There aren't other decisions where men are subjected to similar requirements. And to say that as a matter of decision making, there's an equal protection violation.
I thought, I wasn't making myself clear. I was trying to speak in the language of Casey, and the stuff comes out of Casey. So I was just taking the language in Casey
but
about.
But you actually have to prove it has the purpose or effect of placing a substantial obstacle in her path. So
well, also, but it has to be truthful and not misleading.
Correct. And
so I would focus on effect as opposed to purpose. I was always rather because effect's easier to prove, and I would focus on truthful and honest living. I mean, look, obviously you know this stuff better than I do.
Oh no, I'm not. No, I think it's a conundrum. I think the law. I mean, what I'm trying to sort of demonstrate, it's like a foil for us both, or whatever, is that the constitutional practice and theory don't line up in a way that makes it very challenging.
So that we have to find ways to work into these words, truthful and non-misleading, and effect of placing a burden. We have to find ways of bringing the language, this other language from other cases of dignity in, and we have to leverage both the liberty and equality versions of dignity to try to make something out of it. I mean,
why do you want to stay in Casey as opposed to see if you can get out of Casey? Casey is not, look at Casey, it's not a reversal of Roe, but Casey has something for everyone, but the most important thing it has, right, in terms of being a litigator, is room for the courts to maneuver. So I think the Casey undue burden standard has come to be like, the pornography standard. I know it when I see it, but I've actually never seen it. It's how the courts have responded, and so effect. I mean, the decisions on effect they're devastating.
You just said something that's just fabulous. There is one we know where we saw it, right? What was the one thing where they struck down?
Yes, I agree completely. Yes. Spousal notice, and
that was it, because that was a vision about stereotyping, right?
I think that's absolutely, and I think South Dakota falls on that line, but it's not the legal test that, like, the Seventh Circuit, for example, has laid down in an informed consent case. It's not. Yeah. But I agree with you completely. As I think this is the case on some level where it has that feel of spousal notice. It has the feel of spousal notice.
Although it's O'Connor that we have to thank for spousal notice, and what she says is not the problem is that women are demeaned by spousal notice. Right. She says something else, right? She says, I'm worried about women who are being beaten by their husbands and the risk that this would put them to.
She's got good stereotyping language in there as well, as I recall. So there are the facts about worrying about women being beaten, but there's also the talk about we're no longer the property of men. There's a lot of
great
really
talk
good
in
talk.
there.
That's the thing that's so interesting. But
it has both.
It has very good language. She's as I said, crazy the day I rue Justice O'Connor leaving the court, but here's one of those moments, right?
I rue it all the time.
Because remember when she got appointed?
I know.
Yeah. I'm going to open the floor to questions, if that's all right.
Or solutions.
Linda has one more thing.
One comment, which is that I've always been really puzzled by the framing of the abortion issue as somehow an anti-family issue.
I agree.
And I think one
agree.
way to think about it's inherently a family issue.
Yes.
It's an issue about do you want to start a family? And it's an issue, it's a decision made either in conjunction with the person with whom you've made this fetus, or not, or whatever the circumstances of your life are, but it's inherently about families.
And also, another thing that's sort of doesn't get out as much that should in these facts, like the ones you gave at the beginning about the number of women, is the number of women who have abortions who are already mothers, which is close to half. I mean, it's really high.
I think I'm not wrong. It's the most common surgical procedure in America. It's 1 million abortions a year. Right. So the notion that it's been marginalized as somehow, counter to the family, when the facts are completely the opposite. There must be some way in the English language.
We try to say it's about love and relationships, but which it is, right? It's about whether you're going to have a family, and the way your vision is about having a family, right? Not having a child when you're not ready is about a certain kind of, love and commitment and other issues. I'm not saying that's the legal theory, but I think it's true to why people make these decisions. It goes back to, it's not about which dress you wear. It's about how you envision yourself and how you envision your ability to care for, be with other people.
As a choice of
Emily
mature,
just wants to cut us off.
Mature responsibility.
No, it's just all these hands.
For good
went up,
reason,
and
for
I
good
know that
reason.
people in the room want to.
Right. Okay.
All right, we will take some questions.
Oh, a lot of questions.
Hi, my name's Autumn, and I have a very direct question about strategy and a bigger arena as well. But I also want to back it up in the sort of theme of the panel and what you guys brought up from the beginning to say that I myself had an abortion, and when I finally told my mom, I found out that she had also had an abortion. So I feel like it's one of those things that people don't talk about it until they talk about it. And then I worked at Parenthood for 3 years. So I did policy work as well as was with women during their abortion and during the counseling and the education that led up to that. But my understanding of the way the abortion movement has gone is all of this public opinion and support for women having this choice has been there and has been there throughout, but women just felt like they were safe and that this right was safe because of Roe, and these small chip-aways were not going to actually get rid of the right. So I'm just wondering if you guys think that overturning Roe would be a good thing because it could reinvigorate the base and get people more excited about this, or even that this last legislative session has been a good thing to some degree to get people interested and realize that this is a real issue again.
Every crisis is an opportunity.
I've never liked the idea of overturning Roe, even though it would energize the base, right? Because I think some real people would pay a real price in between. But I agree it's harder to get people, as I say, my friends call me when South Dakota threatens to ban abortion. My friends don't call me when it says, we're going to send you to a CPC. Right. Somehow that gets missed. That's one of the things I sort of found so helpful about your formulation, Jack, was in terms of figuring out how you talk about these restrictions of today as actually going to the core of why we care, in a sense, right? We're here because we care about our ability to make decisions. We care about women being treated as full people. We care about, it shouldn't be that you're selfish, that you had an abortion so you could go to school, have a job, care for your parents, whatever it is. That doesn't, only women really get to be selfish for making those kinds of choices.
I'd be interested in Jack's response to this. I mean, Jack's good friend Sandy Levinson, who famously said Roe is the gift for the Republicans. Roe is the gift that keeps on giving.
Well, actually, Self said about gun control. So,
but that too. Okay.
Well, Sandy and I did this debate in this online debate that still should be around somewhere, in which he said that it would be great for liberals if Roe were overturned, and I said no, it wouldn't. I'm still of that view. I mean, I think what energized liberals and just general public in the late 90s was the fear that Roe was about to be overturned, yes. Which ultimately led to the temporary truce in Casey. The battle has to be a way of articulating that something very, very valuable for women is being threatened. You can do that without basically conceding that Roe has to be overruled.
I don't think I have anything to add. I agree. Yeah, sure.
I'm just wondering, I've heard of women being prosecuted for doing home abortions or ordering the mifeprix or whatever sort of generic version they have over the internet, and there's just recent stories about that. So do you think that kind of news coverage or that kind of information would help in any way to make people realize what the problem is?
Rick Santorum said this week that he would put doctors in jail. I'm not sure what more, I don't know what the answer is on energizing people, or the sort of, you know, the polling is interesting on the generational stuff because it doesn't actually show, like Linda said, what the conventional wisdom is, which is that, you know, older women care and younger women don't. It doesn't really show that. I don't know the answer. But I don't think that overturning Roe is the answer either. I mean, I see the political appeal of it as well, and I do feel strongly that, like, you know, when you can only get an abortion 1 day a week from a doctor who flies in from out of state, and you have to make 2 trips. I mean, on some level, it's like, sure, because people did care when South Dakota was, the voters twice in South Dakota rejected the ban. But it's much easier to sell that narrative than it is for some reason on the incremental on these changes that I do agree. How could you call that an incremental restriction on abortion in South Dakota?
One thing, though, that strikes me is related to what you said. I was wondering about the kinds of stories that are told by married women who already have children about the importance of having abortion available to them. Because that's a story about families. Mm-hmm. That's a pro-family story. Mm-hmm. And I wonder to the extent to which that's an important feature of the argument about the meaning of the Constitution in people's lives. So there's a real struggle. I think this is just another sort of practitioner's note, but I think there's a real struggle of telling stories in the context of litigation, and we've thought this through in some of our cases over a number of years about how we were going to collect women's stories and what we were going to do with them. And, you know, it goes back to the stigma and to the marginalization and to our opposition that we don't feel, even under sort of a Jane Doe type thing, that we can subject. It's a lot to ask someone to be subjected to potential discovery, to a potential hostile deposition. Almost all of our cases now have interveners from the Alliance Defense Fund or otherwise, who, if you're going to put into evidence, it's like a real practitioner's problem. Like, you're going to ask the judge to rely on these facts from some Jane Doe, that they're going to want to then depose the Jane Doe, and a woman who's already driving 700 miles and already has a job and 2 children and, you know, has childcare costs, and, you know, it's a lot to ask them to do, to say, and would you also be willing to tell a court this story and potentially be deposed by someone who's really hostile to abortion, and he'd learn your name and you'd have to sit across from him from a day. And so there's been amicus briefs and other ways we've talked about trying to get more stories involved, and we've worked on that, and I think it's something that we know we have to do. But it's another, like, on the ground, that idea that sounds really good. It's actually tied to the whole idea of the closet, isn't it?
Yes.
That is, if it was Doe versus Texas as opposed to Lawrence versus Texas, you can just see it's just much more difficult.
Well, and I think we'd have to get more narrative discourse outside of the courts before we can get it in the courts, right? Because the courts is so much a heavier lift, just so much a heavier lift. But I mean, I was talking to somebody the other day at the ACLU about whether people telling stories, and it's in part because there were those, you know, It Gets Better videos. Mm-hmm. And so a whole bunch of people, staff, you know, told their stories, and they're on video. And I said, what would happen if we said that at the ACLU, to a video opportunity for staff to tell their abortion stories? I wonder what we'd get just to see what it would look like. And the person to whom I told the story, who's like 10 years older than I am, said, I told my story in the 80s, I wouldn't dream of telling my story today. It's not safe, I wouldn't dream of it. And I'm thinking, like, you're in like a skyscraper in New York. But that's just a sign of the change. And so I think we have to start, before we can get to court, there's a lot of steps, yeah.
Another question. Power of the microphone.
Hi, my name's Yvette, and I'm beginning to wonder if one problem when I read Casey and all these other decisions is that we're beginning to isolate pregnant women, putting them into one of 2 categories. They are either rights holders or they are medical patients based on whether they carry their pregnancy to term or they choose to terminate their pregnancy through abortion. And when I read Casey, you know, in those early abortion decisions, we talk about doctors and the decision to make a decision to make an abortion with your doctor, not wanting to put doctors in straitjackets through informed consent. And now we have completely isolated women from their doctors. As I'm reading the cases, these more recent cases, there's no mention of doctors. Doctors are now even suggested as being harmed by abortion because they are one of the people giving the procedure who has to suffer a consequence under Casey. And this isolation of women from medical care seems to allow the legislatures to now leverage right at that point of the doctor-patient relationship. And I'm wondering if we can't somehow work on bringing back together the idea from the early abortion rights movement of the women's rights model versus the therapeutic model, bringing back together this idea of the role of doctors. So that, and I think it would also help women who carry their pregnancies to term because they are being stripped of rights but being heralded as medical patients, and so you get crazy things like those court-ordered cesareans.
I think it's it's an interesting thought. I think Justice Kennedy has certainly revealed some hostility towards physicians who choose to provide abortions. And he certainly holds, I think, that view, that they're not the same as the doctor he would go to for his home care or something along those lines. So I think there's something, in the Carhart 2 and the preparation for those cases, which was, companion case of Planned Parenthood versus Gonzalez, there was hundreds of hours spent speculating what he would really care about in realms of this. And, he had tipped his hand on that issue in the first Carhart in his dissent. So we knew that going in, and we tried lots of ways. We really did to make him care about the women, to tell their stories. It should have maybe been clearer that the writing was on the wall from that dissent, but there were lots of strategies like that I think are interesting and that we really tried to make an inroad that was, clearly never going to be made in that case.
Well, the historical irony, of course, is that the early movement to reform the old criminal abortion laws was propelled by the public health docs, by the public health community, who viewed the regime of criminal abortion laws as a public health crisis. And it was long before it was a women's rights issue. The women's movement wasn't even, off the ground in the 60s when these doctors were getting on the bandwagon. So it's a very ironic situation.
Another question?
So a couple of questions, which you can answer together. But so one question I have regarding the entire issue of the LGBT movement.
Can you talk into the mic? I can't.
Sorry. My first question is about the notion of the LGBT movement moving faster or moving ahead while abortion rights is moving backwards. But while on the other side, of course, you talk about both the issues are very much linked in the conservative imagination, as I know many of you have mentioned before. So I'm wondering whether you feel that we can respond to both issues, like for example the LGBT movement can also talk about reproductive rights in a meaningful way, or has the new frame that some in the LGBT movement has adopted, which is sort of like pro-family, pro-procreative, pro-children angle, made that argument difficult for the LGBT movement to now really form strong alliance with the reproductive justice movement. The other question has to do with the rise of medical privacy. It seems to be. Do you think that one issue regarding the closet when it comes to abortion is the shift of frame? So whereas it once was maybe a sexual choice issue that people were willing to talk about, just as they may be willing to talk about being gay, again, a sexual choice issue. It's now an issue of medical privacy, and just as I wouldn't want to speak about other medical procedures, I would not want to speak about an abortion. And so the entire structure of medical privacy makes it more, something that I would want to keep in the closet because it's no longer a sexual choice issue.
The more I'm thinking about the relationship between LGBT and this abortion issue, the more puzzling and interesting it becomes. So you just suggested to me that the right frame in both gay rights and abortion is, in addition to the pro-family, procreative frame, is the frame of sexual freedom, right? And that's at least I take one of the things of what you're saying. And in that model, the way in which abortion is stigmatized is the idea that the homosexual, from the standpoint of the 60s and 70s, is queer, not normal, doesn't know how to be an appropriate person of their gender, right? The woman who has an abortion or wishes to have an abortion is also queer because she does not know how to be a mother. She does not understand the proper way of being a mother. And so if we put it in the frame of sexual freedom, then analogically we try to reinterpret what it means to be a mother, right?
Except my caveat would be, what you were talking about sounds more like gender stereotyping, that you don't know how to fit your gender box.
Right.
And the folks in the reproductive rights movement and the LGBT movement, none of us are fitting the boxes. We don't fit the narrative people want to cabin us into, which is different, I think, from sexuality. I mean, we've had these debates a lot at the ACLU, and I just had this, where I think you see the LGBT community having not so much advancing the sexuality frame, right? In part because the narrative about LGBT people, right, that everybody's trying to overcome is that, oh my God, if we recognize LGBT people, everybody's going to be like, you know, hitting on us or on our children, or all these sort of totally venal stereotypes about sexuality associated in particular with gay men more than lesbian women in the culture. So the sexuality qua sexuality, sexual freedom, I think has less immediate promise, at least in terms of people's fears, even though that's than the gender stereotyping. It is about stereotyping all over the place.
I'm going to take one more question. If you want me to choose. No, there's someone with the mic behind
all
you
over,
who's already
yes.
chosen. Go ahead.
Now I'm feeling a lot of pressure to make my question worthwhile. So
No
make
pressure.
a question and a comment. My comment is going to come first. I just noticed that the title of this panel was sort of, it was about reclaiming reproductive freedom, and today I've heard a lot of talk about abortion, and abortion is great, but I just wanted to acknowledge that there's a lot that comes within that reproductive freedom framework that I think we also need to think through in addition to abortion before there can be real choice. But then on the abortion issue, I'm wondering, I've heard a lot, even at this convention, sort of criticizing Roe, and I'm wondering if we could talk a little bit about how to draw a distinction between critiquing Roe and its judicial or legal merits while still respecting the importance of the decision for women and not denigrating abortion rights.
What's the question again? Can you say it again? Say it again. I'm just trying to hear it.
I'm probably actually louder without the mic. Is that better? I'm wondering if there's a way for the progressive community to critique sort of the scholarly nature of Roe as a piece of legal scholarship without seeming dismissive of the importance of the abortion right.
You want to critique Roe?
No.
A lot of other people seem to want to, other panels.
Oh, in other words,
in the theoretical framework of Roe, the legal underpinning.
So I mean, you know, it's sort of, in other words, like that you get cheap goodies from attacking Roe.
Yes.
No, others do.
Other people. Yes, you're right.
And I would like the progressive legal community
Yeah.
to find a better way of making a distinction between doing that and
This is it is the question I need to think about. So let me give you my off the cuff response. I don't know if you were at the plenary this morning.
yes, that's what I'm referring to.
Okay, so yeah, you are on the same page. So I was thinking about it, and I was thinking, you know, this is really interesting. Part of the reason why liberal males especially, got so hung up on Roe was because they had cut themselves loose from very powerful ways of talking about the Constitution. And there were two powerful ways that they should talk about the Constitution it's easy to do, just read nothing. The first is just the Constitution belonging to ours is the text of the Constitution. It's our text. It's what Akio was holding up. Two copies he had actually. You know, pick your favorite version of the Constitution, I guess. But the idea the Constitution is ours, that it's a text that belongs to us, and the liberals were running away from the possibility of arguing from the text of the Constitution to the abortion right. And as I said earlier, there are two ways you can do it. You can do it through privileges or immunities. You can do it through equality. I mean, I think equality given what happened with privileges and immunities. Equality is just the easiest way. I mean, it's just, you just talk about sex equality. Well, the learned lawyer says, what about Geduldig and Feeney? Right? But most people have never heard of Geduldig and Feeney. And,
so lucky.
And yeah. So, and for most people, abortion is about, it is about sex equality. It's just not that difficult to make the point. So you say, what part of equal protection don't you understand? So the first is to claim the Constitution's text as your own and to claim it as part of what it means to be an American. This is a right that you have because you're an American. It's a right that you expected you have, right? That's the first point. So that's about the text. The second point goes to a point that a lot of folks, Reva, myself, Mark Tushnet, Larry Kramer, many, many people, I can't even list them all, and so I feel sorry for not having named them all, is the idea of popular constitutionalism or democratic constitutionalism or populist constitutionalism, or you find the right adjective, constitutionalism. And that's one that tries to connect the rights that Americans have with Americans' views about the Constitution. It's tied to the idea of the Constitution as being ours. I think that this is, and I think what's so interesting about the sort of the Mandarin culture of liberal legalists was that they didn't like the populist strain of constitutionalism. And so for them, it just seemed weird that the way you would justify the right to abortion is you would find out whether or not generations of American women had grown up and said, yeah, this is our right. It belongs to us. This is popular constitutionalism. This is populist constitutionalism. That is a much more powerful argument you can make than any amount of ruminating about the best political theory matched against the best justification of doctrine or the best account of decision cost versus agency cost. I mean, it's just, there's just no, they don't even fit in the same ballpark. So those would be my two pieces of advice to you. Pay attention to the text, argue from the text, claim the text as your own, and claim this is something that's part of our Constitution. Generations of Americans believe as part of their Constitution.
I have one more suggestion on that, which is more, I don't know if it's hostile or not for your conversations, but I guess I would challenge those same people who don't have a problem with Griswold and don't have a problem with Lawrence to explain why they have a problem with whatever you want to call Roe or Casey, or what is it? How everybody supports Griswold, these same textualists, and everybody supports Lawrence. And if you even want to keep it within privacy or dignity or liberty or whatever, why do these rights, do these fundamental things that we understand and they understand the Constitution to include, not include women's ability to act on their own procreative choices? So that would be my other.
I think that is an excellent impassioned question. Thank you so much. I learned so much.